There are a number of sources of the ILO's international labor law and works of supervisory bodies that are implicated by the facts of this case. If we look at this case strictly in terms of actual language of ILO conventions, Convention number 111 and 158 and recommendation number 200 are clearly implicated. Convention number 111 has been ratified in our case. The employer has cited grounds for termination that would be justified in terms of Convention number 158 if it were shown to be the real reason for the termination. Of course, procedurally, the burden of proof is of practical importance in this case, a matter of which Convention number 158 sets a standard. The worker alleges a grounds that implements employer omission to act against co-worker harassment based on the grounds of perceived HIV status. How does national law treat acts of employer omission in terms of discrimination and unlawful employment termination? Is actual agency required to make an employer liable? How does it see discrimination in terms of perceived HIV status? The work of supervisory bodies certainly can contribute to analysis necessarily implicated by the facts of this case. Indeed, the work of the Committee of Experts in this area flows from the fact that provisions of Convention number 111, as well as Convention 158 and Recommendation 200, take the form of directives requiring states to take legislative measures in order to incorporate rights and principles recognized by those conventions into domestic law. You may want to stop here and practice some searching for solutions in NormLex. Look for the term omission in recent comments made on the application of Convention number 111 to see if the committee has doctrine having to do with acts of omission by an employer in a situation where a workplace has become a hostile environment for a worker grounded in a prohibited basis of discrimination. You can see how the committee approaches discrimination under Convention 111 on the basis of perceived HIV status by searching that term. You will find results that are very useful for the domestic case for each of these searches, particularly in the light of the fact that Convention number 111 has been ratified. In this NormLex exercise, we can look immediately to the instruments that have been cited, Convention 100 and 11, and recommendation number 200. First, we can observe that Convention number 111 does not include HIV status among one of its bases of required discrimination. Here you can see what those bases are, but at the same time we can see that the Convention permits additional bases to be determined nationally in subparagraph B. And this is the premise upon which the Committee of Experts makes its comments in respect of HIV status discrimination. We can observe further in Recommendation 200 that it is recommended and suggested that members include HIV status as a basis of unlawful discrimination in terms of Convention number 111. So we have an opportunity for the Committee of Experts to do some doctrine building in terms of these two particular instruments, and it would be in terms of Convention 111 comments. So we'll have a look at those comments. If we go to NormLex and search supervisory comments, Convention number 111, and the term omission, you will come to some 50 comments. The one that is of particular interest involves Gambia, a comment that was made in 2017 and involves an amendment of legislation in Gambia that would include acts of omission by the employer. Take a look at the comment. The committee had noticed information about forthcoming amendments to legislation. The government also indicated that employers who do not take action to prevent or stop sexual harassment may be held liable when it arises from management or employees, and that redress from employers' acts or omissions is generally in the form of compensation for the employee. The committee recalls the importance of adopting explicit provisions defining and prohibiting both quid pro quo and hostile environment sexual harassment in order to properly address this form of sex discrimination. It considers that without a clear definition and prohibition of both quid pro quo and hostile environment sexual harassment, it remains doubtful whether the legislation is effectively addressing all forms of sexual harassment. The committee also notes that pursuant to the present system, the harassed employee is required to resign before redress can be obtained, which is limited to compensation. So the committee asked the government to take action to include legislative protection against sexual harassment explicitly defined and prohibited both quid pro quo and hostile environment sexual harassment, and to include appropriate remedies. These views are certainly relevant to the domestic case we have before us. Now, if you return to the search and reset and look for comments on perceived HIV status, again, search for Convention number 111. Your search may well have taken you to an observation made in relation to El Salvador. Here too, it was a legislative situation that the committee is making comments about, and it is specifically on the issue of real or perceived HIV status. The committee noted that a decree of 2005 reformed the labor code to incorporate a new section which prohibited discrimination against workers on the basis of their HIV status, and also prohibited compulsory HIV testing as a condition for acquiring or retaining employment. However, the committee noted that the Civil Service Act regulating employment in the public service provided that any person who suffers from an infectious or contagious disease may not enter the administrative career services. In its previous comments, the committee noted that the draft legislation to ensure protection from any discrimination on the basis of HIV/AIDS status was pending. The committee notes the government's indication that the bill has still not yet been adopted, but that the draft bill had been submitted. Here you can see that the committee promotes this protection, additional in terms of Convention 111, but promoted by Recommendation 200, as you've seen, and permitted in terms of Article 1.1.b of Convention 111. So both of these comments give the opportunity for a well-crafted argument suggesting that the employer be liable for acts of omission in treating a hostile environment in which the employer ultimately terminated the employee on the basis of the hostile environment the worker faced in the workplace.